Article 4. Property Relations between Husband and Wife. Chapter 1. General Provisions. 74. The property relations between husband and wife shall be governed in the following order: 1. By marriage settlements executed before the marriage. 2. By the provisions of this code. And 3. By the local customs. 75. The future spouses may, in the marriage settlements, agree upon the regime of absolute community, conjugal partnership of gains, complete separation of property, or any other regime. In the absence of marriage settlement or when the regime agreed upon is void, the system of absolute community of property as established in this code shall govern. 76. In order that any modification in the marriage settlements may be valid, it must be made before the celebration of the marriage, subject to the provisions of Articles 66, 67, 128, 135, and 136. 77. The marriage settlements and any modification thereof shall be in writing, signed by the parties, and executed before the celebration of the marriage. They shall not prejudice third persons unless they are registered in the local civil registry, where the marriage contract is recorded, as well as in the proper registries of property. 78. A minor who according to law may contract marriage may also execute his or her marriage settlements, but they shall be valid only if the persons designated in Article 14 to give consent to the marriage are made parties to the agreement, subject to the provisions of Title 9 of this code. 79. For the validity of any marriage settlements executed by a person upon whom a sentence of civil interdiction has been pronounced, or who is subject to any other disability, it shall be indispensable for the guardian appointed by a competent court to be made a party thereto. 80. In the absence of a contrary stipulation in a marriage settlement, the property relations of the spouses shall be governed by Philippine laws, regardless of the place of the celebration of the marriage and their residence. This rule shall not apply: 1. Where both spouses are aliens; 2. With respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located; and 3. With respect to the extrinsic validity of contracts entered into the Philippines but affecting property situated in a foreign country whose laws require different formalities for its extrinsic validity. 81. Everything stipulated in the settlements or contracts referred to in the preceding articles in consideration of a future marriage, including donations between the prospective spouses made therein, shall be rendered void if the marriage does not take place. However, stipulations that do not depend upon the celebration of the marriage shall be valid. Chapter 2, Donation. Section 4. Charges upon and obligations of the conjugal partnership. 1 to 1. The conjugal partnership shall be liable for 1. The support of the spouse, their common children, and the legitimate children of either spouse. However, the support of illegitimate children shall be governed by the provisions of this code on support. 2. All debts and obligations contracted during the marriage by the designated administrator spouse for the benefit of the conjugal partnership of gains, or by both spouses or by one of them with the consent of the other. 3. Debts and obligations contracted by either spouse without the consent of the other to the extent that the family may have been benefited. 4. All taxes, liens, charges, and expenses, including major or minor repairs upon the conjugal partnership property. 5. All taxes and expenses for mere preservation made during the marriage upon the separate property of either spouse. 6. Expenses to enable either spouse to commence or complete a professional, vocational, or other activity for self-improvement. 7. Antenuptial debts of either spouse insofar as they have redounded to the benefit of the family. 8. The value of what is donated or promised by both spouses in favor of their common legitimate children for the exclusive purpose of commencing or completing a professional or vocational course or other activity for self-improvement. And 9. Expenses of litigation between the spouse unless the suit is found to be groundless. If the conjugal partnership is insufficient to cover the foregoing liabilities, the spouses shall be solidarily liable for the unpaid balance with their separate properties. 122. The payment of personal debts contracted by the husband or the wife before or during the marriage shall not be charged to the conjugal partnership except in so far as they redounded to the benefit of the family. Neither shall the fines and indemnities imposed upon them be charged to the partnership. However, the payment of personal debts contracted by either spouse before the marriage, that of fines and indemnities imposed upon them, as well as the support of illegitimate children of either spouse, may be enforced against the partnership assets after the responsibilities enumerated in the preceding article have been covered, if the spouse who is bound should have no exclusive property or if it should be insufficient. But at the time of the liquidation of the partnership, such spouse shall be charged for what has been paid for the purposes above mentioned. 123. Whatever may be lost during the marriage in any game of chance or in betting, sweepstakes, or any other kind of gambling, whether permitted or prohibited by law, shall be borne by the loser and shall not be charged to the conjugal partnership, but any winnings therefrom shall form part of the conjugal partnership property. Section 5. Administration of the conjugal partnership property. 124. The administration and enjoyment of the conjugal partnership property shall belong to both spouses jointly. In case of disagreement, the husband's decision shall prevail, subject to recourse to the court by the wife for a proper remedy, which must be availed of within 5 years from the date of the contract implementing such decision. In the event that one spouse is incapacitated or otherwise unable to participate in the administration of the conjugal properties, the other spouse may assume sole powers of administration. These powers do not include disposition or encumbrance without authority of the court or the written consent of the other spouse. In the absence of such authority or consent, the disposition or encumbrance shall be void. However, the transaction shall be construed as a continuing offer on the part of the consenting spouse and the third person and may be perfected as a binding contract upon the acceptance by the other spouse or authorization by the court before the offer is withdrawn by either or both offerers. 2.5. Neither spouses Neither spouse may donate any conjugal partnership property without the consent of the other. However, either spouse may, without the consent of the other, make moderate donations from the conjugal partnership property for charity or on occasions of family rejoicing or family distress. Section 6. Dissolution of conjugal partnership regime. 126. The conjugal partnership terminates 1. Upon the death of either spouse. 2. When there is a decree of legal separation. 3. When the marriage is annulled or declared void. Or 4. In case of judicial separation of property during the marriage under Articles 134 to 138. 127. The separation in fact between husband and wife shall not affect the regime of conjugal partnership except that 1. The spouse who leaves the conjugal home or refuses to live therein without just cause shall not have the right to be supported. 2. When the consent of one spouse to any transaction of the other is required by law, judicial authorization shall be obtained in the summary proceeding. 3. In the absence of sufficient conjugal partnership property, the separate property of both spouses shall be solidarily liable for the support of the family. The spouse present shall, upon petition in a summary proceeding, be given judicial authority to administer or encumber any specific separate property of the other spouse and use the fruits or proceeds thereof to satisfy the latter's share. 128. If a spouse without just cause abandons the other or fails to comply with his or her obligations to the family, the aggrieved spouse may petition the court for receivership, for judicial separation of property, or for authority to be the sole administrator of the conjugal partnership property, subject to such precautionary conditions as the court may impose. The obligations to the family mentioned in the preceding paragraph refer to marital, parental, or property relations. A spouse is deemed to have abandoned the other when he or she has left the conjugal dwelling without intention of returning. The spouse who has left the conjugal dwelling for a period of 3 months or has failed within the same period to give any information as to his or her whereabouts shall be prima facie presumed to have no intention of returning to the conjugal dwelling. Section 7. Liquidation of the conjugal partnership assets and liabilities 129. Upon the dissolution of the conjugal partnership regime, the following procedure shall apply. 1. An inventory shall be prepared, listing separately all the properties of the conjugal partnership and the exclusive properties of each spouse. 2. Amounts advanced by the conjugal partnership in payment of personal debts and obligations of either spouse shall be credited to the conjugal partnership as an asset thereof. 3. Each spouse shall be reimbursed for the use of his or her exclusive funds in the acquisition of property or for the value of his or her exclusive property, the ownership of which has been vested by law in the conjugal partnership. 4. The debts and obligations of the conjugal partnership shall be paid out of the conjugal assets. In case of insufficiency of said assets, the spouses shall be solidarily liable for the unpaid balance with their separate properties in accordance with the provisions of paragraph 2 of Article 121. 5. Whatever remains of the exclusive properties of the spouses shall thereafter be delivered to each of them. 6. Unless the owner had been indemnified from whatever source, the loss or deterioration of movables used for the benefit of the family belonging to either spouse, even due to fortuitous event, shall be paid to said spouse from the conjugal funds, if any. 7. The net remainder of the conjugal partnership properties shall constitute the profits, which shall be divided equally between husband and wife, unless a different proportion or division was agreed upon in the marriage settlements, or unless there has been a voluntary waiver or forfeiture of such share as provided in this code. 8. The presumptive legitimes of the common children shall be delivered upon partition in accordance with Article 51. 9. In the partition of the properties, the conjugal dwelling and the lot on which it is situated shall, unless otherwise agreed upon by the parties, be adjudicated to the spouse with whom the majority of the common children choose to remain. Children below the age of 7 years are deemed to have chosen the mother unless the court has decided otherwise. In case there is no such majority, the court shall decide taking into consideration the best interests of said child. 130. Upon the termination of the marriage by death, a conjugal partnership property shall be liquidated in the same proceeding for the settlement of the estate of the deceased. If no judicial settlement proceeding is instituted, the surviving spouse shall liquidate the conjugal partnership property either judicially or extrajudicially within 1 year from the death of the deceased spouse. If upon the lapse of no liquidation was made, Any disposition or encumbrance involving the conjugal partnership property of the terminated marriage shall be void. Should the surviving spouse contract a subsequent marriage without compliance with the foregoing requirements, a mandatory regime of complete separation of property shall govern the property relations of the subsequent marriage. 131. Whenever the liquidation of the conjugal partnership properties of two or more marriages contracted by the same person before the effectivity of this code is carried out simultaneously, the respective capital, fruits, and income of each partnership shall be determined upon such proof as may be considered according to the rules of evidence. In case of doubt as to which partnership the existing properties belong, the same shall be divided between the different partnerships in proportion to the capital and duration of each. 132. The rules of court on the administration of estates of deceased persons shall be observed in the appraisal and sale of property of the conjugal partnership and other matters which are not expressly determined by in this chapter. 133. From the common mass of property support shall be given to the surviving spouse and to the children during the liquidation of the inventoried property and until what belongs to them is delivered, but from this shall be deducted that amount received for support which exceeds the fruits or rents pertaining to them.
Chapter 5. Separation of property of the spouses and administration of common property by one spouse during the marriage. 134. In the absence of an express declaration in the marriage settlements, the separation of property between spouses during the marriage shall not take place except by judicial order. Such judicial separation of property may either be voluntary or for sufficient cause. 135. Any of the following shall be considered sufficient cause for judicial separation of property. 1. That the spouse of the petitioner has been sentenced to a penalty which carries with it civil interdiction. 2. That the spouse of the petitioner has been judicially declared an absentee. 3. That loss of parental authority of the spouse of petitioner has been decreed by the court. 4. That the spouse of the petitioner has abandoned the latter or failed to comply with his or her obligations to the family as provided for in Article 101. 5. That the spouse granted the power of administration in the marriage settlements has abused that power. And 6. That at the time of the petition, the spouses have been separated in fact for at least 1 year, and reconciliation is highly improbable. In the cases provided for in numbers 1, 2, and 3, the presentation of the final judgment against the guilty or absent spouse shall be enough basis for the grant of the decree of judicial separation of property. 136. The spouses may jointly file a verified petition with the court for the voluntary dissolution of the absolute community or the conjugal partnership of gains and for the separation of their common properties. All creditors of the absolute community or of the conjugal partnership of gains, as well as the personal creditors of the spouse, shall be listed in the petition and notified of the filing thereof. The court shall take measures to protect the creditors and other persons with pecuniary interest. 137. Once the separation of property has been decreed, the absolute community or the conjugal partnership of gains shall be liquidated in conformity with this code. During the pendency of the proceedings for separation of property, the absolute community or the conjugal partnership shall pay for the support of the spouses and their children. 138. After dissolution of the absolute community or of the conjugal partnership, the provisions on complete separation of property shall apply. 139. The petition for separation of property and the final judgment granting the same shall be recorded in the proper local civil registries and registries of property. 140. The separation of property shall not prejudice the rights previously acquired by creditors. 141. The spouses may, in the same proceedings for separation of property was decreed, file a motion in court for a decree reviving the property regime that existed between them before the separation of property in any of the following instances. 1. When the civil interdiction terminates. 2. When the absentee spouse reappears. 3. When the court, being satisfied that the spouse granted the power of administration
In the marriage settlements will not again abuse that power, authorizes the resumption of said administration. 4. When the spouse who has left the conjugal home without a decree of legal separation resumes common life with the other, 5. When parental authority is judicially restored to the spouse previously deprived thereof. 6. When the spouses who have been separated in fact for at least 1 year reconcile and resume common life. Or 7. When after voluntary dissolution of the absolute community of property or conjugal partnership has been judicially decreed upon the joint petition of the spouses, they agree to the revival of the former property regime. No voluntary separation of property may thereafter be granted. The revival of the former property regime shall be governed by Article 67. 1 for 2. The administration of all classes of exclusive property of either spouse may be transferred by the court to the other spouse. 1. When one spouse becomes the guardian of the other. 2. When one spouse is judicially declared an absentee. 3. When one spouse is sentenced to a penalty which carries with it civil interdiction. Or 4. When one spouse becomes a fugitive from justice or is in hiding as an accused in a criminal case. If the other spouse is not qualified by reason of incompetence, conflict of interest, or any other just cause, the court shall appoint a suitable person to be the administrator. Chapter 6. Regime of Separation of Property. 1 for 3. Should the future spouses agree in the marriage settlements that their property relations during marriage shall be governed by the regime of separation of property, the provisions of this chapter shall be of suppletory application. 1 for 4. Separation of property may refer to present or future property or both. It may be total or partial. In the latter case, the property not agreed upon as separate shall pertain to the absolute community. 1 for 5. Each spouse shall own, dispose of, possess, administer, and enjoy his or her own separate estate, without need of the consent of the other. To each spouse shall belong all earnings from his or her profession, business or industry, and all fruits, natural, industrial, or civil, due or received during the marriage from his or her separate property. 1 for 6. Both spouses shall bear the family expenses in proportion to their income, or in case of insufficiency or default thereof, to the current market value of their separate properties. The liability of the spouses to creditors for family expenses shall, however, be solidary. Chapter 7. Property Regime of Unions Without Marriage. 1 for 7. When a man and a woman who are capacitated to marry each other live exclusively with each other as husband and wife without the benefit of marriage, or under a void marriage, their wages and salaries shall be owned by them in equal shares, and the property acquired by both of them through their work or industry shall be governed by the rules on co-ownership. In the absence of proof to the contrary, properties acquired while they live together shall be presumed to have been obtained by their joint efforts, work or industry, and shall be owned by them in equal shares. For purposes of this article, a party who did not participate in the acquisition by the other party of any property shall be deemed to have contributed jointly in the acquisition thereof if the former's efforts consisted in the care and maintenance of the family and of the household. Neither party can encumber or dispose by acts inter vivos of his or her share in the property acquired during cohabitation and owned in common without the consent of the other until after the termination of their cohabitation. When only one of the parties to avoid marriage is in good faith, the share of the party in bad faith in the co-ownership shall be forfeited in favor of their common children. In case of default of or waiver by any or all of the common children or their descendants, each vacant share shall belong to the respective surviving descendants. In the absence of descendants, such share shall belong to the innocent party. In all cases, the forfeiture shall take place upon termination of the cohabitation. 1 for 8. In cases of cohabitation not falling under the preceding article, only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. In the absence of proof to the contrary, their contributions and corresponding shares are presumed to be equal. The same rule and presumption shall apply to joint deposits of money and evidences of credit. If one of the parties is validly married to another, his or her share in the co-ownership shall accrue to the absolute community or conjugal partnership existing in such valid marriage. If the party who acted in bad faith is not validly married to another, his or her share shall be forfeited in the manner provided in the last paragraph of the preceding article. The foregoing rules on forfeiture shall likewise apply even if both parties are in